This is not DEI with a megaphone. This is not what we saw happening during the Biden administration. This is DEI hidden with a law degree. It doesn't shout, it whispers. And it's going to carry down the whisper stream until we start seeing changes taking place. It is not demanding compliance, but what it does is it induces it, making little things by us focusing so much on bias and perception and not understanding, making it look like we're being compassionate by doing so. What it does is it induces compliance.
Revolution of common sense.
Revolution of common sense.
A revolution of common sense.
Truth was once common sense, but today, truth is uncommon. Explore biblical truths around faith, business, and politics with Peter Demas. Uncommon sense in current times.
I continue to hear people talk about how DEI is dying and showing examples of how this has taken place. But recently, I had a class that explained to me that DEI is not dead, but it's shifting to real cultural change right before our eyes, and we will not see it happen if we don't pay it attention. Lawyers and government officials generally don't react to a problem until it's right in front of them, not while it's developing. So let me tell you what happened. Recently, I attended an online course for my continuing legal education credits called Diversity, Inclusion, and Elimination of Bias in the Legal Profession, New Rules and Training. And it's by Howard Lotham, I don't know if I'm pronouncing his name correctly, in Independence, Missouri. Now, I want to start very clear about what this episode was about and what it is and what it is not. This is not about slogans. It's not about corporate HR training videos. This is not about whether people should be kind or respectful. It's not about accusing one speaker of bad motives. That's not what I want to do. But to me, this is something that is more serious and more subtle, and we need to be very careful. We're watching a shift away from an open, explicit DEI mandates into something quieter, more insidious, more professional, more dangerous if left unexamined. It's not DEI as a policy. It's an operating logic and a new moral framework. And if you miss it, it's because it does sound reasonable. Then you'll wake up later wondering how the rules changed without a vote. I've spoken before on how culture shifts. Cultural shifts often start small. They're framed a lot as compassion or protection. Dissent is ignored or framed as harmful. Institutions start to adapt it first, and then by then it's too late. I'm critiquing this legal training, not specific to the training itself, but to an underlying shift from DEI to the idea of bias. So let me just start with my ground rules. I am not going to tell you what he actually says. Not what I think he means, not what I fear it could become, even though I will talk about a little bit of that, but what he actually puts on the table. So let's see what he's happening now. He says bias is everywhere in the legal system. It exists at every level. Judges, juries, lawyers, clients, staff. Modern bias is rarely overt. He says it's subtle, it's unconscious, it's linguistic, it's environmental. It often happens before anything illegal occurs. Throughout the class, he repeatedly emphasizes that language matters, that tone matters, and how things land matters. And he repeatedly warns that we need to watch what's coming, watch the news, watch legal publications. That matters. That's a warning about risk, not law. Now, let me remind you, this is a CLE class. It's a continuing legal education class. It is designed to update lawyers on law and law practice, and he is ignoring the law to focus on risk. So what he says should happen. He tells lawyers to be proactive, not reactive. That we need to anticipate bias before complaints arise, and we need to listen to perceived harm before evaluating facts. But this is the part that I don't get. Every perception of harm contains assumptions of facts, but he is giving his perception as authoritative. Perception is not authoritative, but that's the position he's taking. He is saying that we ought to adjust language and behavior accordingly, and we should not rely on intent as a defense. This is the part that I don't fully get either. Any policy statement defense can be challenged without intent, which leads to a selective enforcement. I'm reminded of a SNL skit a long time ago with Tom Brady when they're talking about sexual harassment. It's really funny. You look it up online with it. But basically, they were saying that if you're good looking, it's not sexual harassment. So he was doing all sorts of outlandish stuff, but it wasn't sexual harassment because he was good looking. Meanwhile, you had the large person, the ugly person who would just say good morning, and it was called sexual harassment because they were ugly. What ends up happening ultimately on this is it leads to self-censorship and has a chilling effect on speech. If my intent is irrelevant and only your perception matters, then why should I speak? Furthermore, he's a criminal lawyer. Intent is everything in these laws. There is a difference between first-degree murder and manslaughter, but a dead person doesn't have perception, so I guess facts will have to work only in those situations. We adapt even when the standards are unclear. He even admits nobody knows what it means. Like, this is an education class, and he says nobody even knows what it means, yet he still urges compliance. I mean, that sentence hinges on this entire lecture that he has. So I want to slow this down a little bit, point to where people get confused and why systems quietly change. Because nothing he says is extreme. Nothing he says is lawless. Nothing he says sounds ideological. And that's where the danger really lies. So I'm going to look at it one step at a time without skipping anything. Step 1, he redefines the background condition. Before he tells lawyers what to do, he tells them what kind of world they're operating in. He says that it's everywhere. It's not just some people. It's not bad actors, not isolated cases. He says everywhere, judges, juries, lawyers, clients, staff, institutions, everything out there, he says, has these biases. But once you frame bias as ambient, it stops becoming an allegation and becomes a condition. It's no longer something you have to prove. It's always there and you assume it. That's the first step. Step number 2, he relocates bias from conduct to atmosphere. He tells you that modern bias is not primarily explicit or intentional or overt. He says it's subtle, it's linguistic, it's unconscious, it's environmental. In fact, what he would argue is that by me saying this, I'm showing you my bias already from the start, and therefore you can dismiss it because my bias doesn't matter, and those who are perceiving it wrongly is a problem. It's no longer tied to discrete acts. It's tied to tone and phrasing, silence, emphasis, and context. It is atmospheric. It becomes hard to locate. It's harder to disprove. You can't limit it. That's step 2. Step 3, he now takes harm away from illegality. He tells you something very critical. Bias and harm exist before anything illegal occurs. So again, those that I said in step 2 that I might be harming on their perception on it, now it's occurring before anything illegal occurs. This should make all lawyers uncomfortable. It should make all people operating within a law, which means you, everybody who is under the law, uncomfortable. Because in law, harm is something that becomes actionable after a threshold is crossed, not before. But he's telling you the real problems arise earlier. This is where law starts to lose exclusivity over judgment. Number 4, he weakens intent as a limiting principle. You cannot rely on intent as defense. It doesn't abolish it formally. It just neutralizes it practically. Because if intent does not protect you, good faith doesn't protect you, neutral purpose does not protect you, lawful motivation does not protect you. Our intent is sidelined, and the system must find another way to judge conduct. Number 5, he elevates perception as consequential. He constantly emphasizes how things land, how they're received, how it's perceived. He urges lawyers to listen to perceived harm before evaluating facts. And it sounds compassionate, but legally it does something very specific. He treats perception as action triggering, not just informative. I would always look at perception. When I did practice law, I would look at perception. I would perceive what they thought. I would look at what they thought was really harmful. I do it now in business. I say sometimes perception of the customer is actually bigger than reality. But at the same time, I'm looking at it as information, not as action triggering. Perception at this point in time no longer waits for facts. Facts are invited later, if at all. Number 6, he admits standards are unclear, but insists on compliance. This is huge. He says nobody knows what it means. And yet he doesn't say, let's wait for clarity. He says, we got to adapt. We got to watch what's coming. Be careful. How do you do that? I don't know what it means, so I just got to adapt anyway. How do I adapt to unknowing what to do? That's so illogical, which flies in the face of what the legal profession is about. But this means that enforcement continues even when standards are undefined. Step 7, which is the conclusion. Once you accept all those previous steps, the condition follows whether he states it or not. Following the law is necessary, but no longer sufficient to avoid risk. It's not only speculation anymore. It's the only way the system can function given the premises that he lays down. DEI is now shifting to this nice little system here that, again, we can't see it developed. Each of those little steps are so small and incremental that you can't tell because you're like, yeah, bias makes sense. Yeah, you know what? I do care about when somebody gets hurt. I should do that. And even as a Christian, I should care when other people are harmed. But we don't look at the consequences that comes from it from there. So let's talk about what happens next after the conclusion is accepted. Look, under the way the law has always worked, risk comes from violating a statute, breaching a duty, engaging in a prohibited conduct. That's kind of the basic stuff when it happens. You know where the line is. Here's the line, it's the law. Now, you could be ignorant of that line, and that's not a defense. But at the same time, once you're told where that line is, then you know exactly, oh, I crossed the line and I made a mistake in that area. I have a friend of mine who is who didn't want to pay payroll taxes once he found out he had to. He opened up a little small independent restaurant. He got in trouble with it. And he was like, I don't like having to pay this. Well, it doesn't really matter. At that point in time, he already crossed the line. He got in trouble for it. But we knew where the line was. But under this new bias framework, risk now comes from how words might be interpreted, how decisions might be perceived, whether harm is experienced, and whether bias can be inferred. Not implied, by the way, inferred. That means they see it this way. So even when no rule is violated, we still can run into this problem. This is not hypothetical. In modern institutions, complaints triggered investigations without findings. Investigations used to be rooted in fact, but now they create reputational harm, and the process itself becomes punishment. We see this frequently. I've seen how the law changes when I actually practice law and engage in sexual harassment, and now I have to investigate it, when I have an employee to do it. And again, it's not too unlike the SNL skit with Tom Brady. We have to take every one of them seriously. We investigate every single one of them. But I have people now, even when I present the facts to them, get angry and say it doesn't really matter because they felt a certain way. That bias is changing. That way we look at it, the perception is changing on how we're supposed to act and how we're not supposed to act. Right now, the law and facts are on my side. But what happens when that person's perception overcomes? And we're going to talk about this from a business perspective as well as from a Christian perspective toward the end. Our culture doesn't need more noise. It needs a different kind of courage. Right now, the loudest voices are often the angriest. And sadly, many Christians assume the answer is to either get louder or just as bad, stay silent because they're afraid. Yelling isn't courage, and being belligerent isn't bold. The greatest threat to Western Christians today isn't persecution, it's fear. Fear of losing relationships, fear of losing income, fear of losing the comfort we've built. And here's the truth. Real courage doesn't suddenly appear when pressure rises. Boldness isn't built in a crisis, it's trained. Formed through prayer, scripture, obedience, and small daily choices long before the high-stakes moment arrives. If we want to stand firm when it matters, we have to start practicing boldness now. That's the purpose of my newest book, Bold, Not Belligerent. We look at the obstacles that prevent you from being bold and the small disciplines to train you for when the moment arrives. The world doesn't need belligerent Christians. It needs bold ones who are ready to stand. As a result of this, behavior changes before the law changes. Law becomes the floor and culture becomes the ceiling. Once risk is tied to perception, the rational response is anticipation. So let's make it concrete. For lawyers have to move from asking, is it lawful, to could this be seen as a problem? That changes what arguments are safe, how you cross-examine. How do you cross-examine somebody if you might hurt their feelings? It changes what clients you could take. So you could be actually harmed, but if the perception out there is different, they may not take you as a client. You may be accused of it, and they may not take you because of how this changes. Again, I don't think this is next year or around the corner. This is the beginning of what happens. This is the developmental stages when we're seeing DEI move from above ground to below ground. And now it's beginning to shift underneath us, and we have to be careful and aware of it. You could be on the right side of the law and still be wrong culturally. For business owners, they move from compliance with the law to managing perception risk. We're already seeing that now. We see businesses that say, well, we don't want to say Merry Christmas because it might be offensive. It's a perception of risk. Legally, you can say whatever you want to say on it. But then they pass that down to their employees. Well, now they got another problem because some employees are going to be offended by Merry Christmas. Other employees are going to be offended by Happy Holidays. They can't win. And now they have to write policies that are written to avoid offense, not liability anymore. But how can you write a policy that places a customer over your employee's perception of fairness? Because sometimes they can be mutually exclusive depending on how entitled your employee is. And it can also work the other way depending on how entitled your customer is. But in business, especially in customer service, your customer does come first. Discipline is filtered through identity optics now, but that shifts. How can a business owner ever discipline? If I'm looking at it, it's going to be constantly shifting. I feel this way today and you can't do it. I feel this way tomorrow and so you can do it. I wouldn't know how to be able to do it based off of the fluidness of this perception of bias is the problem. But according to this class, I'm supposed to adapt anyway, regardless of whether I know, and no one seems to know, but I got to adapt anyway. And that's true for you. When you're going out trying to live a lawful life, you got to adapt anyway, regardless of how the other side's going to take it. Doesn't really matter anymore, according to what this class is encouraging lawyers and changing it to. This is not because people voted for it, but fear and vagueness always moves behavior. And that's what this is. Fear of getting in trouble and the vagueness of the intent that is here. So I want you to see the system shift, where it's moving from and what it's moving to. It's moving from statutes and case law to professional expectations and cultural norms. Authority moves from law to culture because he admits the standards are unclear and he says you had to adapt anyway. Again, that to me I don't understand that. He moves from intent and conduct to impact and perception. It moved from what did you actually do to how did it land? Who felt harmed? Because intent is unreliable. He says do not rely on it. Perception is going to fill the vacuum. You move from neutrality to contextualized treatment. The same rules for everyone is where we are now. And we're moving to a context situational judgment with expectations that differ from person to person. We move from evidence to experience. I want to go back to the last one. If any of you have more than one kid, you generally know that the same way to discipline one child does not work for the second one. Now, I don't know, you may be lucky and you may be able to get away with both, but not for me with my 2 kids, not for my parents with my 2, or my wife with her parents' 3 kids. Everyone had to be disciplined differently. One way works for one child, one does not work for another. Okay, we have to kind of make those changes, but imagine if that was part of the legal system and you had no clue. You didn't raise them. You weren't around them from birth going forward. So again, on the surface, it sounds legitimate, but in reality is in practice and logistically, it doesn't work at all. You move from evidence to experience. We move from testimony from cross-examination, corroboration, objective standards, to lived experience as authoritative, negative credibility. We're already seeing this right now. Supreme Court is listening to arguments on the trans athletes, and we're already seeing this because they feel like a certain gender. We got to treat them like that gender, but since that gender, they can be gender fluid and it can change. We got to figure out what their gender is from day to day. That's not how the law works. And here's the biggest piece we lose in this entire legal American justice system. We lose due process. This is something that is so critical and just baffles me that any lawyer would get up and make this argument about bias because due process is the foundation of our entire legal system. It is guaranteed by the federal government in the Fifth Amendment of the Constitution and the 14th Amendment, where it's given to states in the U.S. Constitution as well. Due process is a critical component. Due process, though, depends on structure. It depends on fair notice. But undefined norms eliminates notice. If we don't know what bias is, we don't know what the perception is, we no longer can give notice. And if we can no longer give notice, then we give a due process. Due process requires that the accuser proves wrongdoing. But here, the accused must disprove perception. The due process gives us a presumption of innocence. But under this framework, bias is presumed, not innocence. Due process allows you the right to challenge your accuser, but challenge is now treated as insensitive. How can we challenge somebody anymore? Because we might hurt their feelings even more because of that perception and that built-in bias perception that he does. Due process allows for neutral judgment. Decision makers interpret context, and consistency erodes. Because whenever you can look at all these different things, you no longer can be consistent. I don't know what happened in your case might be completely different in mine. I've gone before planning commissions to ask for something, and one of the things if I'm asking for a variance, one of the questions they have to ask is, well, if I do it for you, what happens if I have to do it for everybody else? Like, what's going to make this different? How can I limit this from getting out of hand? If all bias is bad and has to be accounted for, how can any judge or jury ever adjudicate any case? Why doesn't this lawyer appeal every one of his decisions on the basis of bias? Right now, he can't because the law is there. But if we're supposed to be switching to this new way of doing it, that's dangerous. Again, it's under the surface, moving the ground in front of us, and we won't recognize it unless we speak out about it and see it now. And once risk is governed by perception rather than rules, due process becomes optional. And once due process becomes optional, law stops becoming the law. Now, let's look at this from a Christian perspective. Because what really concerns me is this is not just a change in the legal system. It's not a change in the way that businesses operate. It's not a change in the way that we can operate with one another in a legal civilized system. But now what this does and what he is advocating for is the foundation of a rival moral system. DEI was a little bit more obvious. It was a little bit more religious-like in the way that it was presented. But this here is laying a foundation. Now, Christian justice does agree with some of his concerns. Partiality is a sin. False weights are condemned. Oppression matters. But the differences between the two are profound. One is truth. Christianity insists truth exists outside of perception. There is such a thing as truth. But this framework destabilizes truth. That's why he can't define it, and no one knows what that means. Responsibility. Christianity assumes that people, or Christianity assigns that people are responsible. They assign responsibility to each person individually. This framework diffuses guilt through identity. The identity changes and accountability just kind of goes out the window. Impartiality. Christian justice demands equal judgment. But this framework justifies unequal treatment. Now, notice how he took out the word equity in the title. It's no longer diversity, equity, inclusion. It's now diversity, inclusion, and elimination of bias. But what this is just another hidden term for equity. You will often see, and we talk about this a lot, they change definitions, they change terms to mean the exact same thing. One way didn't work, so let's just shift it and move it over here. Christian justice talks about proof for repentance and forgiveness. Well, this framework, all it does is sustain and promote an accusation without resolution. Authority. Christian justice limits power through law. This framework expands discretion by being ambiguous. This is not a Christian justice system. It is a rival moral system. So let me end this here. This is not DEI with a megaphone. This is not what we saw that was happening during the Biden administration that was really big in 21, 22, 23. That's not where it was. But this is DEI hidden with a law degree. It doesn't shout, it whispers. And it's going to carry down the whisper stream until we start seeing changes taking place. It is not demanding compliance, but what it does is it induces it, making little things by us focusing so much on bias and perception and not understanding, by us making it look like we're being compassionate by doing so. What it does is it induces compliance. The danger is not what is explicit today. The danger is what the framework will permit for tomorrow. History teaches this lesson clearly. When rules gives way to perception, power always fills the gap. And we will see that time and time and time again. Power will always fill the gap. And in our system, in our U.S. system that we have, our constitutional republic that we have, the power is supposed to belong to the people. But whenever the people stop giving up rules and start making it all about perception, then the power is going to jump in. This is why we saw during these times of DEI, where some people would be not inclusive of certain thought processes. They would not include diversity if it was from a white Christian male. They wouldn't include that type of diversity. This is why they would call Black Christians, they would call them names and make accusations of them. Why would they do this? Because power is filling the gap. Christians, lawyers, and business owners, and just again, people that want to operate in the law and work within a legal system. It would also include business employees. That we should care deeply about this, not because they oppose compassion. That's not why you should care about this, but because you understand justice. Justice requires the truth. Justice requires clarity. Justice requires restraint. And once those are gone, they will not come back easily. So thank you so much for listening, and pay attention out there. It's time we need to start thinking and start acting before it becomes a problem, not after it becomes one. And then it just sounds like we're just spitting in the wind. Thank you so much, and God bless you.